The retrial of Karen Reed, accused of killing her boyfriend, Boston police officer John O'Keefe. It began on April 1st of 2025, following a mistrial due to a hung jury last year. Prosecutors allege after a night of drinking, Reed dropped O'Keefe off at a fellow officer Brian Albert's home in Canton, Massachusetts. And they say she intentionally struck him with her SUV, leaving him to die in the snow. They cite evidence such as a broken taillight on Reed's vehicle, fragments of that taillight found on O'Keefe's body, and the defense contends that O'Keefe was fatally injured, but that it happened inside of the house, and that Reed is being framed in a cover-up involving law enforcement. They point to alleged investigative misconduct by former lead investigator Michael Proctor. He was later fired for inappropriate behavior during the investigation. And now, as the prosecution gets close to wrapping up their case in chief, will an accident reconstructionist be the Commonwealth's final witness? And can he convince this jury Karen Reed is guilty beyond a reasonable doubt? Tonight, we have all of the latest and all of the big moments as this retrial of the century continues. Good evening and welcome to Closing Arguments. I'm Julia Janae, filling in tonight for Vinnie Politan. Thank you for being with us for this huge day today for the prosecution in the retrial of Karen Reed. Everything unfolding, we're all watching it play out in Dedham, Massachusetts. And today was a big day because of what this jury was able to see. They were able to see something in a very different way. And if you think back to Karen Reed's first trial, the one in 2024, the one that ended with a hung jury, you'll remember the testimony of this man, Trooper Joe Paul. He's with the Massachusetts State Police. He was called to reconstruct the scene, to testify about the prosecution's theory of what happened to John O'Keefe. Trooper Paul's deduction from the evidence in this case was that he believed John O'Keefe was struck in the right arm by Karen Reed's SUV going in reverse at a high rate of speed, causing him to spin around. And it was quoted in court as a pirouette that he did, and then landing on the ground. And that characterization left a lot of people, and possibly some jurors, scratching their heads with more questions than answers. And while the Commonwealth's theory hasn't changed too much since last year with that last trial, their expert this time around has. And today we heard from the testimony of that expert, Judson Welcher. We've been hearing a lot about him throughout this case before we even got to today with him actually making his appearance. And unlike last year's expert, he included some very compelling visual aids. Now, these demonstrations, are they what the prosecution was lacking in the first trial that couldn't get a guilty verdict from that jury? Will this be enough to convince this jury this time around? Let's ask someone who knows all of the things happening inside and outside of that courthouse. We have Court TV crime and justice correspondent Matt Johnson, who is joining us this evening from outside of the Dedham, Massachusetts courthouse. Matt, let's start with that demo. The demo of Dr. Welcher using paint to show this jury something. Walk us through it.
Julia, nice to see you. Wow, another big day here in Dedham, Massachusetts for the retrial of Karen Reed. It is day 21, and we are rapidly approaching the end of the Commonwealth's case in chief, and they may end with this bombshell testimony and demonstrative aids from this big witness. We have Dr. Judson Welcher on the stand. He's the crash reconstructionist we have heard oh so much about leading into the retrial of Karen Reed. He works with the company Aperture, and they did something so unique that we haven't never seen before. They purchased what is alleged to be the murder weapon in all of this, an identical version of that SUV. They purchased identical glassware that the waterfall had used. And then you notice right there on your screen, identical clothing that victim John O'Keefe was wearing in the night in question. He ran a number of tests and demonstrations, including the SUV backing into him slowly. Take a listen to this.
I did this at very low speeds, and you'll see, and we'll throw this from two different angles. That's me showing I'm doing test 2. This is from a camera that we have pointing down at it. This is the speed. You'll see it's only about a 2-mile-an-hour impact. but even a 2-mile-an-hour impact redirects me back and causes me to rotate and take a step.
Your Honor, can we approach, please?
Yes.
Karen Reed shaking her head in court as she's watching this demonstration, maybe for the first time. Well, we've seen it for the first time and today, and these jurors were paying close attention. One part of it was very impactful, though. It was where the paint alleged to line up with where the injuries would be on Officer John O'Keefe. That was very powerful. These jurors were taking a lot of notes with that slide, Julia.
Matt, that was a moment inside of the courtroom. When I saw it happening on the screen in my office, I got up and got even closer to the screen because I'm thinking, this is the first time I'm seeing a reconstruction in this way for this trial. So tell me about something else that Dr. Welcher talked about having to do with this other incident. And we know the defense has said that this could explain the taillight damage having to do with John O'Keefe's SUV in the driveway of their home.
Yeah, you know, this was another example of trial 1 versus trial 2, and it's been very night and day with the experts that they're choosing. They're not going with the state troopers on the stand, Trooper Joe Paul. Instead, they hired this company. And for this test, it's to do with a ring video that we've seen and heard about oh so much. It's part of the defense case where Karen Reed says that she backed into Officer John O'Keefe's SUV that's parked there in his driveway. She says that's how she got that cracked taillight in the first place. Well, this doctor, he lined up these vehicles. He did some measurements. It was all data driven. And here's what he said about that scanning of that material.
I had the opportunity to inspect Mr. O'Keefe's vehicle. There's no damage where these marks are. So, sure, it knocked the snow off, but it wasn't sufficient to cause damage to his vehicle. This is after the Lexus has pulled away. Looking in the snow, I see nothing in the snow.
Were you looking for anything in particular?
Of course I was. I was looking for taillight fragments.
In any of the videos that you have that show Mr. O'Keefe's vehicle after the defendant's Lexus touches it, do you ever see any remnants or shards or fragments of taillight on the ground?
I do not.
He analyzed the vehicles, and again, he did the digital scan, and he had the vehicles side by side. There was a lot of testing with these two vehicles as to the collision and whether or not the taillight could have been broken by impact. But again, he determined that there was no damage from a backup maneuver by Karen Reed in that driveway. But he is yet to be cross-examined on all of this tomorrow.
Oh, yeah. So tell us about that, because if we've got the cross-examination tomorrow, we have been hearing rumblings. Matt, you always are on top of things there at the courthouse, that this may be where the prosecution ends their case. What are you hearing now tonight?
Well, it's such a powerful witness, and really they're hoping to use this witness to connect all the dots for what happened in the night in question. And we also know that this could very well be the last witness because they're going to put on a rebuttal case. And Hank Brennan has said that in open court, and that will be determined by what the defense puts forth. But today ended very abruptly. He has yet to continue his direct examination and weigh in on his opinion as to what happened that night with the alleged collision itself. Take a listen.
Based on all the evidence you considered, could you share with the jury what your opinion is to a reasonable degree of engineering certainty about whether the defendant's Lexus struck Mr. O'Keefe on January 29, 2022, around 12:32 a.m.?
Objection, Your Honor.
Going to remember.
I can answer. Yes, based on the totality of the evidence, DNA, everything I've talked about, that is consistent with that happening. With a reasonable degree of scientific certainty, that is what happened.
Objection, move to strike, Your Honor.
So I'm going to strike that.
So again, this doctor was on the stand, this crash reconstructionist, all day long, and he was going through his methods of testing and how the injuries to Officer John O'Keefe, in his opinion, could line up with parts of the vehicle. But he has yet to give his opinion officially on how the crash took place altogether. And that's the missing piece for this juror with the Commonwealth's case in chief. Outside the courthouse, once again, we got comment from this defendant, Karen Reed, as well as her father. Take a listen.
PhD does not equal an MD. PhD does not equal an ME. And the state's own medical examiner could not determine the manner of death. Additionally, the state's own medical examiner said, consistent with injuries struck by a vehicle, she would have expected something below the waist. So I'll leave it at that for tonight, okay?
He backed up into himself at 2.2 or something miles per hour. So he tried to dress identically to John, but didn't do anything else to mimic what the Commonwealth is accusing me of.
So did you go in reverse 24 miles an hour, 53 feet?
The data is what the data is, and it's going to come out cleanly, more cleanly in our case in chief. I think it's important to demonstrate what is the Commonwealth accusing me of. The speed, the positioning, recreate that for us. Back up into the crash test dummy at 24.2 miles an hour in the arm and see what happens. That's what I would want to see if I were you.
Do you recall that at all, Karen, though?
No, because it didn't happen.
Yeah, once again, you know, when we get to the defense case in chief, we're expecting ARCA to take the stand once again for the retrial. Karen Reed has also told me and the other journalists here that it's going to be a much more robust case than what they put on last year. Today, I asked her if she plans to testify this time around. She said no comment. Julia?
Still no comment from Karen Reed. A more robust case from the defense, but clearly a more streamlined case from the prosecution. Matt Johnson, thank you so much for that live report. Let's bring in our think tank to talk about all that we saw today. We've got our Massachusetts insiders back with us tonight. First, we have criminal defense attorney Joseph Krowski Jr. with us. Also, author of Storm and Suspicion, the Karen Reed Trials, Kevin Lanahan is here. And finally, Karen Reed supporter. You'll recognize him from being behind the defense inside the courtroom most days. Nick Rocco is here as well. Good to see you all. Joseph Krowski Jr., let me start with you. We've got grease paint, a slow-moving Lexus. Is this going to move the jury, this paint demo? Do you think any jurors are thinking, aha, this is the light bulb moment?
Well, it, of course, is going to move the needle. If it doesn't move the needle, then the jurors are ignoring the science and the engineering in the data. You've got to remember that this expert only harvested the data. He didn't create it. He didn't manufacture it. Pretty ominous admission and concession from Karen Reed. The data is the data. So she was backing up 24 miles an hour for at least 50 feet with the accelerator depressed at least 74% when the expert opined she struck John O'Keefe. What I liked what this expert did, he's the same size, essentially the same height and weight, and was for the first time you saw how those injuries could line up with specific parts of the Lexus motor vehicle, including the wind dam accounting for the laceration to the eye, the arm being bent lining up with the tail light, and other parts of the body. So to me, this was a knockout moment for the Commonwealth. The data doesn't lie.
Yeah, we're going to talk a lot about that speed, Joseph, in terms of the backing up soon. Let's talk about this demo, Kevin. What did you think about it? I've been wanting to see an animation in this case. We've seen it in other trials. I know there's not a lot that each of these sides know in order to make an animation. Do you think this is going to be the closest that this jury is going to get to some kind of reenactment of how things happened?
Yeah, it seems to be. And I think sometimes people in the public, all of us have maybe a unrealistic expectation where we're looking for that smoking gun, perfect explanation. But what the prosecution has done here is eliminated one by one any possibility so that there's only one left. And the only one that's left as John being struck by that Lexus. There's just nowhere else to retreat to. You're not going to get a perfect explanation for exactly every single wound on that arm, but you're getting a very reasonable explanation, and there is no other explanation. So I think that's where we're left here.
Okay, Nick Rocco, take us to the other side. What is this reenactment of sorts missing? What does it not take into account?
Well, it doesn't take a lot into account. I mean, considering the fact that they're accusing her of going 24 miles per hour in reverse and striking him, they're showing us a demonstration of 2.2 miles per hour. And, you know, he claims he rolls off the vehicle. I think one of the biggest things that he was testifying to was he doesn't know exactly where John was standing when this happened. He doesn't know the position his arm was in, yet he stands there with his arm holding a cocktail glass directly out in front of him. And one of the big issues I find with this is Karen Read drives 34 feet forwards, puts the car in reverse, drives 53 feet backwards, all while John is just standing there with his arm out holding a glass and doesn't even move out of the way. So you're insinuating he's standing there watching, maybe not watching, but he's standing there as Karen Read is backing up and doesn't even move and just gets taken out by this vehicle and you know, gets thrown 30 feet or whatever they're going to claim tomorrow into the yard, and that's how he received the gash to the back of his head.
We are going to talk about that movement because I think that's going to be key for this jury, key for the defense in refuting it. Our think tank is going to stay with us. When we come back, we're going to have more about this accident, Reconstructionist, the movements of Karen Read's SUV, plus here's a preview of what's coming up in the next hour on VPI. Tonight on Vinnie Politan Investigates, Carrie Roberts and Jennifer McCabe, two Massachusetts moms called by the Commonwealth to testify about what they saw the morning John O'Keefe's body was found in the snow. What do these witnesses from the scene add to the prosecution's case?
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, tonight, 9/8 Central, only on Court TV.
Karen Read is in the midst of the retrial of the century.
She is factually innocent. She's guilty.
There's something wrong in this county.
Come at me.
The Karen Read murder retrial. Live coverage weekday mornings, 8/7 Central, on Court TV.
So 0's the start. The vehicle goes forward about 34 feet. Then you can see it basically stops in this area here. Then begins to back up and ends up backing a total of 53 back from where it originally started. So if you add 53 to 34, you get 87. So the total motion, 34 forward, 53 back. The Lexus moved 87 feet total.
Those were the calculations and findings of accident reconstructionist Judson Welcher. And on the stand, he did more than just a reenactment with grease paint when he evaluated Karen Read's SUV. He also calculated an important distance, 87 feet, the movements of Karen Read's vehicle that prosecutors allege is the motion of the murder. Welcher didn't testify in the first trial, signifying that the prosecution, they hope that the way he describes this scene is going to speak volumes to the jury. Here's how he said Karen Read's SUV moved around 12:32 a.m., January 29th of 2022.
So this is 10, 20, 35, forward. And then I'll go 10, 20, 30, 40, 53 back for a total of 87 feet. So from the maximum point I pulled forward to where it backed up, again, that was 34 feet forward, then a total of 53 back, total travel distance of 87 feet. So went all the way forward where it stopped, it then backed up 87 feet. And when the tech stream data stopped, it's still moving. It's still moving about 23 miles an hour, and you're still at 74% throttle and 3,300 revolutions per minute on the tachometer, RPM gauge.
34 feet forward, 53 feet back, a total of 87 feet of movement. Still with us, Joseph Krosky Jr., Kevin Lenahan, and Nick Rocco. Kevin Lenahan, let me start with you. Let's talk about this distance. And the speed is important as well. Do you think the jury is going to have a good understanding of what this looks like, moving that fast in front of a house in a residential area?
Yeah, it's at night. It's outside. There's no witnesses. We're not sure what Karen was or wasn't aware of, but you just look at the fundamental data that shows that there's no way this could have been faked or fudged. She missed a three-point turn on Cedar Crest Street and had to turn around. And by looking at a couple of different data sets, you can tell plus or minus a few seconds exactly when that happened. And it's 8 minutes and 8 seconds after that three-point turn that Karen let the Lexus struck John going in reverse, and you have the telltale signs of a pedestrian strike. There's no way somebody could have manufactured that. Those timestamps come from the correlation with John's phone and from some other data points. So I think the jury's, it was simply enough presented that I don't think the jury's going to have a problem understanding it.
So, Nick, we heard Karen Reed outside of the courthouse saying the data is what the data is. Let's talk about what the defense is going to do with this information, because ARCA doesn't necessarily dispute that this is what the data shows. Can you remind us how they characterize it, or what we expect that they're going to characterize it in front of the jury?
Well, since the first time they testified, they've done more testing. So we'll have to wait to see when they testify to see what other testing they have done. But one of the biggest things is they don't actually know at what speed John was struck at. So I believe if it's 53 feet that she had backed up, then that's going to prove that Jen McCabe had also lied when she puts Brian Higgins' Jeep out front, because most likely she probably would have struck Brian Higgins' Jeep if she was traveling that fast, going that distance, or Higgins' Jeep wasn't there. But I think another big thing, too, is the jury did not get to see what it would look like with an arm being struck at 24 miles per hour going into reverse. The only dummies that we saw today was when he had dropped the dummy backwards and said, okay, look, that's how someone could hit their head. But if John was clipped, as they're trying to say, he would have most likely spun out and not landed directly on his back. So you're going to have a lot, cross-examination is going to be very interesting come tomorrow.
I agree. I 100% agree. I can't wait to hear what they ask him on cross after all of this, and especially digging into these reenactments and visual aids. Joseph, let's listen back to Dr. Welcher on the stand talking about the length of time all of this took.
Do you have an opinion to a reasonable degree of engineering certainty about the entire distance that is captured in that 10-second window of the second triggering event, 1162-2?
So it obviously only captures what's going on during the trigger. It doesn't capture before or after the trigger.
Understood. Do you have an opinion as to just what is captured as far as the distance?
Yes.
And what is your opinion?
That it's 87 feet.
Joseph Krosky Jr., this trigger is a little triggering because you only know what happened during these events. We didn't even hear a lot of testimony about what speed she would have left and how far she would have gone before stopping after leaving, what direction. Your thoughts on this testimony and whether this is where the prosecution should end their case for now?
So this testimony is compelling. To put it in perspective, this is a hit-and-run case, and your typical hit-and-run case, it's not captured on video. You might have a piece of hair and some damage to the car and some evidence of operation. You don't have the type of data with precision that the Commonwealth has offered in this case. You cannot cross-examine the software engineered by Toyota Lexus. It is damning that she pulled forward without obstruction, stopped, put it into reverse, and backed up at least the 54 feet. Now, that was key cycle 1162 subsection 2, and it captured that 10 seconds because she depressed the gas pedal with so much force, it registered a key cycle event. Now, keep in mind, we're talking about John O'Keefe's body was found right in close proximity where she backed up at least 54 feet at 23 or 24 miles per hour. At the same time, his phone stopped moving.
Joseph, a follow-up, when we're talking about this movement into his body and him ending up on the lawn is what the argument is. What more could the defense, what's their argument going to be in front of this jury when it comes to that 87 feet? Because Karen, you mentioned she said the data is the data, but what's she going to say to explain it? It's not the three-point turn. It's not turning around. What's another reason that she could have been going forward and going back?
Well, I don't think that. I think it's circular logic, right? There's not a good explanation for why you would back up that amount of feet at that speed at the exact time John O'Keefe stopped moving. And again, what the expert did, it wasn't necessarily a reenactment. It was just showing that it is consistent with him being struck when you talk about angles and sizes. I think what he did, we should appreciate, he took a conservative approach. No one can actually memorialize it like a video camera would if it's not captured on video. That's going to be something, again, her saying the data is the data. I don't know how you get around that. I don't think you can.
Kevin, is this part of the case, you think, the reason that we've got not just a manslaughter case, but that prosecutors felt like they had to charge second-degree murder?
Yeah, the third prong of manslaughter, second degree in this state is basically the reckless endangerment. So we know, and we now have more information on that because we know from Ian Whiffin's testimony that John got out of the car and locked his phone just seconds before he was struck. And so this is around the same, so only a moment or two after that is when Karen backed up. So she should have known, or certainly did know, that he was in the vicinity. So whether she intended to strike him or not, her act of driving back that recklessly and that fast satisfies the third prong of second degree. Now, whether as a practical matter, a jury will consider that malicious intent is another in question, but it does satisfy it.
All right, it'll be up to the jury at the end of the day on this, but there were some problems with this expert on the stand's testimony. The jury may not have heard it yet. Our Karen Reed insiders are going to stick around after the break. We have a little preview of what we can expect from cross-examination of the accident reconstructionist.
Dr. Welcher, you have changed your PowerPoint presentation in the last few days in this case, correct?
I deleted a slide and removed a couple words.
Right, but you've changed your PowerPoint presentation, correct?
Correct. I deleted a slide and deleted a couple words.
Cross-examination should begin tomorrow for the accident reconstructionist Dr. Judson Welcher. And even though the jury hasn't heard the defense grill this prosecution expert yet, his methods have already been critiqued by another prosecution witness. Last week, we heard from Shannon Burgess. He works at the same firm, Aperture, as Dr. Welcher. And he was called because a few weeks ago, he discovered something that he says Welcher and other experts missed in Karen Reed's SUV, that SD card that captured the Lexus's movements embedded in an infotainment system. So as soon as Welcher came into court today, outside the presence of the jury, the defense wasted no time in asking Dr. Welcher if he had spoken with his colleague before testifying. Here's more of that voir dire in front of the judge.
I understand that you intend, subject to our objections at the court's ruling, you intend to present testimony with regard to your PowerPoint where you are going to elaborate on your 1231-38 to 1231-43 trigger 1162-2, and you're going to add to what has been in your presentation a verbal discussion with regard to Mr. Burgess's change that he made in his May 8th report with regard to the variance time window. Do I have that correct?
No, you don't. It's not based upon a verbal discussion. It's based upon his report.
Okay, so you're going to make, you propose, what you're intending to do is you want to add the change from Mr. Burgess's May 8th report to what you're going to testify to on your PowerPoint. Do I have that correct?
That is correct.
And the only reason you're going to testify with regard to altering the 1231-38 to 1231-43 window is because of what Mr. Burgess has done on May 8th. Is that correct?
It's better data, so I'm altering it and correcting it with better data that I've received from Mr. Burgess.
Right, but my point is, if it weren't for Mr. Burgess's change, you wouldn't be making any changes in your testimony, correct? It's only because of what Mr. Burgess did on May 8th. Is that correct?
Only from his report, correct.
Correct. So, and you understand, sir, that that change has significant effects on the very issues in this case with regard to the timeline and the collision you allege occurred, and comparing it to human volitional conduct of Mr. O'Keefe with regard to his manipulation of the phone. You understand the consequences of that change, do you, sir?
I do. I would disagree with your assertion that this is consequential. Again, my original data, which is in my PowerPoint and has not changed, that data is still there. The timing was extremely close within the error of the measurements, which Mr. Burgess ultimately showed in his subsequent report that was within the variance associated with those timing devices.
I understand, but my point, sir, and I want to understand if I have it correct, is that is going to move the time that you assert the 1162-2 trigger occurred, correct?
Correct.
And you would agree that's a substantial change given the issues in this case when seconds matter? Or do you think it's an insignificant change?
I wouldn't say it's insignificant. Again, I haven't modified my PowerPoint at all. I was happy with the data I had and satisfied with the data I had. Again, once presented as engineer would with better data, we use better data. I'm sorry.
Please, for voir dire, let him finish.
Yeah.
It brings it closer in time to Ian Whiffin's last contact point data. But even if we don't have that, given what I knew about the variance in the cell phones, my time was still within that window anyway.
Sir, you've just answered my question, which is you agree that it affects the timeline in the activity of Mr. Whiffin's report. You said brings it closer. Did I have your words correctly?
Correct. What I was concerned about was your word about significant change. It brings it closer. It doesn't necessarily bring it significantly closer. My original timeline was very close, within the range of the accuracy of those types of cell phones, infotainment system data. So even if I didn't have Mr. Burgess's subsequent report, the data is still within that time window.
Sir, isn't it a fact that with the variance of Mr. Burgess that you're now you want to testify to, that there is a change because your 1162-2 trigger 1231-38 to 1231-43, you know that there's a device lock event on the phone of Mr. O'Keefe after that time period. You understand that, correct?
So again, there's a window of plus minus on that. Technically, those timestamps on that are, as you indicated, again, there's literally, I wrote that on my slide. It includes my slide where I have that exact comment.
But my question, sir, is the change means now that with the Mr. Burgess variance moving, you now have part of the moving range that occurs after the device lock, whereas before your change, the device lock occurred after every bit of your range of 1162-2. I have that correct, don't I, sir?
You do.
Okay. Your Honor, that's all I needed. Thank you.
So that real cross is tomorrow, but even outside the presence of the jury, that's giving us a preview of what we can expect when things start up. Let's bring back in the think tank, Joseph Krowski Jr., Kevin Lenahan, and Nick Rocco. Nick, let me start with you. What do you think about how this cross is going to go and whether Shannon Burgess has created a real problem for the prosecution?
Well, I think it's just going to show that, you know, a month into this trial, they still were uncertain about the evidence that they had. And then all of a sudden, Burgess puts this report in on May 8th, which now changes the testimony of Welcher as well. And then also, too, you know, we see an example of how the cross is going to go. We saw how it went with Burgess, and I don't think it ended up really being well for him. And I have a feeling that unless he's going to point out a lot of facts that are going to go against what Welcher and the Commonwealth believe happened. But I think also, too, one of the big things that happened, and I'm sure they may talk about it more tomorrow, is that as an expert, you know, you're not allowed to say that this is exactly or definitively what happened. And he tried to do that at the end of the case today, and you know that got stricken from the record and then pulled right up to sidebar, because I'm sure Welcher knows when you testify as an expert, you cannot say definitively this is what happened. So, you know, the jury did hear that. They know it's stricken from the record, but I'm sure they're going to get a message from Judge Beverly Cannoni tomorrow morning.
Yeah, first thing on whether or not they have to disregard it. It was objected to. Maybe the prosecution question, we'll ask it in a different way. Joseph Krosky Jr., your thoughts on how this all played out? The weeks into trial, we're getting another report. That witness took the stand first to not bolster because he's beforehand, but just from a criminal defense attorney's standpoint, what do you think about the way that the prosecution handled Welcher and Burgess in front of the jury?
We have to remember the timeline here. The defense was adamant and married to using ARCA in this case, and it was objected to by the Commonwealth, the late disclosure of ongoing testing by ARCA, and that pushed the timeline back for everyone. When the Commonwealth received the reports from ARCA, of course, they're going to review those reports, and the experts are going to review those reports, and they're going to do ongoing analysis of the data. What's really important here, though, is Burgess was able to do a chip-off of the SD card from the infotainment center. That allows them to get a precise timestamp of an earlier event. That's 1162.1, the three-point turn at Cedar Crest Road. They were able to calibrate the exact time of that by looking at the data from John O'Keefe's phone, and they came up with a variant of 21 to 29 seconds. If I understand Judd Welcher correctly, he already had a variant in his timeline, in his PowerPoint presentation, that is within seconds of that. So it really doesn't change the data. And again, you can cross-examine and you can interpret, but you can't change the data. One quick point to Nick's point. I understand what he's saying, that you can't testify to exactly what happened, but that's really a legal principle, that you can't testify to an ultimate issue. You can testify based on your experience and all the data and information that you reviewed, that there was, in fact, a collision or a pedestrian strike at a set date and time, which is, I think, what Welcher's attempting to do.
And you mentioned that chip-off and the SD card. Kevin, are you surprised that other experts missed that? That it took until a month into trial that we are now hearing this new evidence in a case that has been investigated for years?
Yeah, I mean, no investigation is perfect, and these mistakes were made not just by the prosecution, by the defense. In the original chip-off that was done before the first trial, the troopers weren't able to complete the chip-off, so they had to get the help of the defense expert, but she didn't get it properly done either and missed one of the main chips here that we're now getting this new data from. So the defense is it's fair game for them to go after any last-second changes here. But what it'll come down to is whether the explanations by the experts were clear to the jury. And just to go back to Burgess's testimony last week, it was so perfectly clear and simple that on the one side, you got the defense going after, did he get the date wrong, which had to look really weak to that to the jury. And on the other hand, you have him giving this very clear explanation and getting it down to within a couple of seconds or less exactly what time these events happen. So if that is clear, and I thought it was very clear today, and it was very clear with Burgess last week, I don't think it leaves any room. And like I said earlier, there's just nowhere else for the defense to retreat to on these issues.
And the defense case is going to be starting really soon. Nick, this is witness number 38 that's going to be returning to the stand tomorrow. Last year, at the end of the case in chief, they were on witness number 68. That's a lot of witnesses that weren't called. Do you think the defense is going to be, or can we expect that the defense is going to call a good chunk of those prosecution witnesses who were skipped this year?
Well, I will say the one thing I'm thankful for with Hank Brennan is he didn't call all these unnecessary witnesses, but I don't believe the defense is going to call the people inside the house. They may or may not call Michael Proctor, but at the end of the day, it's the Commonwealth that's hiding these people from the jury. I mean, you have a dead police officer on the lawn, and you don't even call in majority of the people that were in the house that night, that were at the party, who specifically Julie Nagel is the only one that testified last time that she saw a 6-foot black blob on the lawn. She's the only one placing an object or some sort on the lawn. And Hank didn't even call her. So there has to be reasons why, obviously, he's not calling them. Most likely he wants them on cross-examination because he is a defense lawyer. But the last thing I'll say is I truly believe, obviously I'm on the side of the defense, but I truly believe when you have the ARCA guys compared to the Aperture guys, It's just going to be two different ball games, and that's why the DOJ hires people like Arca versus Aperture.
Battle of the experts, maybe what it comes down to. Great analysis from everyone. Thank you so much for breaking all of this down for us. Our Massachusetts insiders, Joseph Krowski Jr., Kevin Linehan, and Nick Rocco. I know we will see you all again very soon. When we come back, we are going to go to a break, but something else you need to know is on the other side. Plus, coming up in the next hour on VPI. Tonight on Vinnie Politan Investigates, prosecutors say data from Karen Reed's SUV and John O'Keefe's cell phone can pinpoint the moments in which a deadly collision occurred. But the defense says the data tells a different story. So what does the data add to this case? We investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
What do we really know about Diddy parties?
Get a new look at the evidence and the latest from inside the courtroom. Vinnie Politan Investigates, a Diddy special report, June 4th on Court TV.
Click on it.
Welcome back. It's time for us to reveal something else you need to know tonight. Today was day 10 of the sex trafficking trial for hip-hop mogul Sean Diddy Combs. He's facing RICO charges in New York. The federal government called a former employee to the stand today, Capricorn Clark. She detailed a grueling time as Combs' personal assistant, detailing allegations of threats, kidnapping, and being blacklisted. Cameras are not allowed in federal court, but here's a listen to the details from a court transcribed with the help of an AI-generated voice.
Were there any other individuals around you aside from Mr. Combs and Mr. Offert in Central Park that night?
No.
What, if anything, did Mr. Combs tell you at that time?
He told me he didn't know that I had anything to do with Suge Knight, and if anything happened, he would have to kill me.
What concern did you understand Mr. Combs to have?
Objection, Judge. Sustained.
What was Mr. Combs?
I'm sorry, Judge. I'm going to ask to strike the last answer.
I don't believe she answered.
No, I mean the question and answer before.
Grounds?
403.
That's overruled.
Ms. Clark, what was Mr. Combs' demeanor when he threatened that if anything happened, he would have to kill you?
Calm.
Did you have the opportunity to observe him in this conversation?
Yes.
How did you perceive this threat?
Very serious.
Why is that?
I felt like there was some gravitas to the fact that he might have had issues with Suge.
I'm going to stop you right there, Ms. Clark. What, if anything, did Mr. Offert state when Mr. Combs made that threat to you?
Nothing.
Was he nearby?
He was.
What was his demeanor?
Calm. Stoic.
How did you react when Mr. Combs threatened you?
I said we'll just have to see.
What did you mean by that?
I meant there was nothing I could do in Central Park to convince him that I was a trustworthy person. I knew my character. I knew that I didn't have anything to do with any of that stuff, that he would possibly have any.
Objection, Judge.
That's sustained. The jury should disregard the witness's answer. Ms. Steiner.
Did you continue to work for Mr. Combs after this incident?
I did.
Why did you continue to work for him?
I felt maybe I could have been more transparent.
Transparent about your background?
Yes.
Was this the only time that Mr. Combs threatened you?
No.
She detailed more threats and also talked about a key witness, Cassie Ventura, who we are learning breaking news about today. She reportedly is in labor. Recall she took the stand the first week of this trial. TMZ was the first to report this breaking development, and People magazine says they've confirmed the news with an unnamed source that Cassie is in a New York City hospital in labor with her third child. She was 8.5 months pregnant on the stand when she was testifying. Court TV is working to independently confirm this information. When she took the stand at trial, both the prosecution and defense took great care of examining her on the witness stand due to her late-stage pregnancy. We'll bring you any updates as we get them. And before we go tonight, though, and end this hour, I want to show you this picture. This is Kora Heavenly Quiroga. She's 16 years old, was last seen May 12th in Salt River, Arizona. If you have any information on where she is, you can call 1-800-THE-LOST. Let's see if we can get her to a safe place. Stay with us. VPI.